does the Second Amendment guarantee the right to possess AR-15s and magazines?
There are 3 types of bans, and it doesn't really matter because they all do the same thing.
The right to keep and bear arms shall not be infringed.
Critical rifle and magazine ban challenge that's currently in front of the Supreme Court and is once again heading to Supreme Court conference this week.
It's a case that legal experts will be watching closely.
Senate Bill 3 saw the most reaction from the public.
There is a whole slew of gun control legislation that's going to be coming down the pike.
This ban doesn't just regulate firearms, it outlaws some of the most common and popular rifles in America, which are in fact protected by the Second Amendment.
Federal court just admitted something shocking about AR-15s that could change everything you thought you knew about the Second Amendment. They acknowledge these rifles are owned by millions of law-abiding Americans, yet in the same breath, they ruled that states can still completely ban them. This isn't some minor legal technicality. This is a direct challenge to the very foundation of your constitutional rights. What's happening right now in the Supreme Court could determine whether the Second Amendment actually means anything at all. A groundbreaking case is about to be considered that asks one simple but explosive question. If a firearm is commonly owned by millions of Americans for lawful purposes, can the government still take it away? The answer might not be what you expect. The case heading to the Supreme Court is called NAGR versus Lamont, and it challenges Connecticut's sweeping ban on AR-15 style rifles and standard capacity magazines. But here's where things get really interesting. The lower court didn't even try to argue that these items aren't in common use. They openly admitted that yes, millions of Americans own these rifles and magazines legally. They just decided it doesn't matter.
This is big.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
They really don't know what to do with this one, which is always a good thing to see.
The Supreme Court has made a decision on the first major Second Amendment case in decades.
I want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Think about that for a moment. A federal appeals court essentially said that even though the Supreme Court has clearly stated that commonly owned firearms are protected by the Second Amendment, judges can still decide to ban them if they personally think they're too dangerous. This isn't interpretation of the law. This is rewriting it entirely. The Connecticut law at the center of this controversy doesn't just regulate these firearms, it completely prohibits their sale, transfer, and possession. The state criminalizes anyone who owns magazines holding more than 10 rounds, turning law-abiding citizens into potential felons overnight. The plaintiffs challenging this law aren't asking for special treatment. They're simply pointing out that these are the same firearms and magazines owned nationwide for completely lawful purposes like self-defense, training, and sporting activities.
House would keep gun owners' information private.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
Government may not regulate individuals' possessions of weapons for self-defense.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
When this case first went to federal district court in Connecticut, the plaintiffs sought what's called a preliminary injunction, basically asking the court to stop enforcing these bans while the case was being decided. The district court refused, saying the challengers were unlikely to win their case. That decision was then appealed to the Second Circuit Court of Appeals, and this is where things took a truly bizarre turn. The Second Circuit panel did something almost unprecedented in constitutional law. They actually agreed that AR-15s and standard magazines are in common use. But then they performed what can only be described as legal gymnastics to uphold the ban anyway. According to their reasoning, the Supreme Court's previous rulings in cases like Heller and Bruin don't really mean what they clearly say. The Supreme Court has been crystal clear. The Second Amendment protects weapons that are in common use for lawful purposes. It's not a complicated standard. If millions of Americans own something for legal reasons, the government can't just ban it. But the Second Circuit decided they knew better. They created their own test, deciding that courts can still ban commonly owned items if judges think they're unusually dangerous. This completely destroys the entire framework the Supreme Court established. Under this logic, Any judge could ban any firearm simply by declaring it too dangerous, regardless of how many law-abiding citizens own it.
California cannot ban gun owners from having high-capacity gun magazines.
There's nothing in the Second Amendment that says that you can ban magazines or any crucial part of a firearm.
The justices will decide if it violates the right to carry weapons in public for self-defense.
Aimed at declaring various federal gun restrictions unconstitutional in the state.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
The common use standard becomes meaningless if courts can just ignore it whenever they want. What makes this even more troubling is how the Second Circuit reached their decision. The Supreme Court explicitly told lower courts in the Bruin decision that they cannot engage in what's called interest balancing, basically weighing public safety concerns against constitutional rights. The Constitution already did that balancing, and the Second Amendment won. But the Second Circuit did exactly what they were told not to do. They dressed it up as historical analysis, claiming they were looking for historical analogs to justify the ban. But in reality, they were doing the same old interest balancing that the Supreme Court rejected. They looked at factors like perceived lethality, military features, and tragic shootings, then used those to override constitutional protections. This is precisely the approach the Supreme Court said was unconstitutional.
The right to keep and bear arms shall not be infringed.
My response to that is that's the same claptrap that they have been using for 20 years.
The Second Amendment protects the right to carry a gun in public for self-defense.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fairer process for everyone.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
The petitioners in this case are making a powerful argument. They're pointing out that throughout American history, the only weapons that could be banned were those that were both dangerous and unusual. The key word there is and. Something can't be banned just because someone thinks it's dangerous if it's also commonly owned. AR-15s and standard magazines owned by tens of millions of Americans cannot possibly be considered unusual by any reasonable definition. By labeling commonly owned arms as unusually dangerous, the Second Circuit essentially gave judges unlimited power to ban whatever they personally don't like. This isn't constitutional interpretation, it's judicial activism at its most blatant. The court is literally rewriting the Constitution to reach the outcome they want. What makes this case particularly significant is its timing. The Supreme Court recently had Justice Kavanaugh suggest that they would address rifle and magazine bans in the near future. This case presents the perfect opportunity to do exactly that.
Red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better.
Magazines are essential and a common part of a firearm, therefore a protected right.
The state's ban on magazines holding more than 10 bullets strikes at the core of the right to bear arms.
This is something that actually comes from common law England. The king is sovereign and the government has to waive that sovereign immunity.
71-page decision where he talked about the fact that, hey, a magazine is a necessary part of a firearm, and therefore it is protected by the Second Amendment.
The Second Circuit's defiance of Supreme Court precedent is so clear, so obvious, that it practically demands intervention. The stakes here couldn't be higher. If the Supreme Court allows this ruling to stand, it essentially means the Second Amendment offers no real protection at all. Any state could ban any firearm simply by having a judge declare it too dangerous, regardless of how common or lawful its use. The constitutional right to bear arms would exist only on paper, subject to the whims of whatever judge happens to hear the case. This case is scheduled for Supreme Court conference on January 23rd, where the justices will decide whether to hear it. There are also two other major rifle and magazine ban cases being considered this week, which could impact how the court handles this one. If those cases are granted review, this case might be held or consolidated with them. If they're denied, it could signal trouble for this challenge as well.
Major Supreme Court ruling.
Everybody has a right if they're a responsible adult.
It triggers something in me that something has to be done.
This is currently the rule until they decide to change their minds, which they inevitably probably will.
Not giving notice, well, that's required. And when you take that away from people, you don't
follow the rulemaking process, and you have to invalidate the rule.
PF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
This case could reshape how far states can restrict your right to carry and where.
The petitioners are stressing the urgency of Supreme Court intervention. They're arguing that lower courts across the country are openly defying Supreme Court precedent, and without clear guidance, this defiance will only continue. Law-abiding citizens are being turned into criminals for owning items that millions of Americans possess legally, all because some judges have decided they know better than the Supreme Court. This isn't just about AR-15s or magazines. This is about whether constitutional rights mean anything at all. If courts can simply ignore Supreme Court precedent and rewrite constitutional standards whenever they disagree with them, then no right is safe. Today it's the Second Amendment. Tomorrow it could be free speech, religious liberty, or any other fundamental right. The Second Circuit's ruling represents exactly the kind of resistance to Supreme Court authority that demands immediate correction. They didn't just misapply the law, they openly defied it. They admitted the firearms in question are commonly owned, then banned them anyway, using a standard the Supreme Court explicitly rejected. This level of judicial defiance cannot be allowed to stand if the rule of law means anything.
And Republicans are pushing to get a new version of what they call the Second Amendment Preservation Act passed.
Saying setting a higher threshold in an emergency could mean life or death.
This will get appealed, and this might go back and forth a little bit. But for right now, this is where we're at.
We won't see changes overnight, but it's going to be quick.
As we wait to see what the Supreme Court will do with this case, one thing is clear: the future of the Second Amendment hangs in the balance. Will the court step in to enforce its own precedents and protect constitutional rights, or will they allow lower courts to continue ignoring the law and stripping away fundamental freedoms? The answer will shape the future of gun rights in America for generations to come. The fact that a federal court can openly admit that millions of Americans lawfully own these firearms, yet still uphold a complete ban on them, shows just how far some judges are willing to go to undermine constitutional protections. This isn't interpretation, it's nullification, and only the Supreme Court can stop it. That's it for today, folks. See you in the next video.